Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay, how is everybody? Hello, Dark Side. Hello, She-Fly. Hello, Elaine. Hello, Maestro. Hi, Liz Graham. I just came on early. We're having people over tonight, so it's going to be a madhouse in this apartment. So I just decided to come on early and do my show early. So whoever's catching it live, I'm sorry to everyone. It's a little rude of me not to announce it earlier, but sometimes life is just hectic like that. Thank you, Liz. So yeah, right? Not kosher. Thanks, Sonny. Not the kosher couple again. Someone else. So big Karen Reed news. Let's start off with her civil hearing. I mean, so much to talk about. Karen Reed, civil ruling came down. So she was putting in a motion to dismiss, which means like throw out charges against her. And she got 2 no's and a yes. We'll go over it. A pretty short to the point ruling. So let's bring that up first. Also, in other news, Karen Reed lights a match last night as soon as Free Karen Reed was content, made nice with Aidan Turtleboy Kearney for the allegations. And you can listen to the evidence of it on my channel in the shorts that he taped Karen Reed without her consent or knowledge. She drops into JFK's show last night and she was in the chat and she was saying, yeah, he taped me and things are over. So she's publicly making a break with Aidan Turtleboy Kearney. Is this, I mean, so many interesting things about what's going on. Also, I mean, is this just because, I mean, the rumors, I mean, they may just be rumors, but the rumors of some kind of grand jury investigation into Karen Reed and witness harassment is certainly going wild. We saw Chris Albert yesterday was leaving the courthouse just as the grand juror, Jessica Leslie, pled guilty and got sentenced. She got sentenced yesterday to 2 years of probation and 2 months of home confinement. And her attitude, Grant Smith Ellis caught her and her mother, and their attitude is something to behold. As the only one in the courthouse was Grant Smith Ellis reporting on it that I heard. I know mainstream media, but giving a play-by-play of everything that went on, a real detailed rundown. And he was saying that she gave this tearful speech And I'm really suspect of these like tearful speech. And her lawyer said she did it for Karen Reed. She wanted to free Karen Reed. That's why she was leaking grand jury information. So indeed, it does have very much to do with Karen Reed. And is Karen Reed making this public break with Aidan Turtleboy to keep her followers always one step ahead right before there's some kind of grand jury indictment into this? They have her phones. Cosgrove just asked to get into her phones. Does she have her ear to the ground? That's the question. I don't mean to look at it in a spiritual way, but odd, right? Just the timing of all this stuff is just very odd. Like, I mean, Aidan Kearney has been public about taping his phone calls for a long time. She had to know. Or she had to suspect. This is really what's going to blow up their relationship. It just seems like, to my eye, that she doesn't need him anymore. She's now inviting JFK. She's discarding him just the same way she discarded John O'Keefe at the end. She was looking for other people while desperately pretending in the text messages to be hanging on to the relationship. She knew it was over. She wasn't leaving. She was just going to make sure she could leave in the way that she wanted, that she could hurt him. So Commonwealth, Massachusetts, Paul O'Keefe and others. Cici's hospitality. This matter arises out of the January 29, 2022 death of John Joseph O'Keefe III, defendant and moving party Karen Reed, and was previously charged with several crimes in connection with JJ's death. During the pendency of Reed's criminal case, plaintiffs Margaret O'Keefe, JJ's mother, John O'Keefe II, JJ's father, Paul O'Keefe, JJ's brother and personal representative of JJ's estate, and Kaylee Furbish, Kaylee, JJ's niece, filed this civil lawsuit asserting claims against Reed for wrongful death, negligent and or reckless infliction of emotional distress, and negligent, reckless, and intentional infliction of emotional distress. The plaintiffs also asserted claims for wrongful death and negligent infliction of emotional distress against Cici hospitality against Cici hospitality. Moreover, Reed made the looks like there's a page missing here. Moreover, Reed made these statements. I mean, anyway, I'm like, made these statements upon waking up Kaylee at 4:30, which was plausibly contributed to the distressing nature of the interaction. Even this court were to accept Reed's position that she was merely engaging in telephone conversations, conduct otherwise reasonably made because torturous when directed at an individual known to be particularly susceptible to infliction of emotional distress. Buell. At the time of this interaction, it can be inferred that Reed knew Kaylee was a vulnerable minor who previously lost both parents and lived with JJ as her surrogate parent. Given such status, Kaylee would be particularly vulnerable to distress caused by additional loss of a parental figure. Thus, based upon Kaylee's vulnerability and susceptibility, Reed, at a minimum, knew or should have known that her conduct would cause Kaylee to suffer emotional distress. This plausibly supports a claim for intentional infliction of emotional distress. Therefore, the defendant's motions to dismiss are denied as to their arguments regarding the sufficiency of Kaylee's claims. This is really good news. Wherefore, the defendant's motions are allowed as to the negligent infliction of emotional distress asserted by Kaylee, and denied as to their claims for reckless and or intentional infliction of emotional distress. So what does this mean? This means that they cannot sue, the O'Keefe family cannot sue Karen Reed for negligent infliction of emotional distress, but they can sue her for claims for reckless and or intentional infliction of emotional distress. I would love to talk to a lawyer about really the difference in those claims. And the defendant's motion are denied in all other respects. So, I mean, a lot of no's for Karen Reed there. This is a good sign with this Judge Daniel O'Shea. I hope he stays on the case, right? What does everybody think of that? Good news. Good news for the O'Keefe family. Very bad news for Karen Reed. It's all going forward. Yes, Massachusetts is a two-party state. You have to get consent. You do need consent to tape someone. Not in New York City, but in New York, but in Massachusetts. You do. So that is that. Really good news. Should we all just soak in the good news? Yeah, I hope he stays on it. I don't know. You just don't know. I know he was especially appointed on that case. I'm almost there. What do you mean I'm almost there? I'm almost there. What? Diddy got 4 years and 2 months. Whoa. Wonder what that means. Yeah, in federal cases, you don't get that time off for that you do in state cases. That's good news too. Could have gotten a lot more, but at least the women of New York will be in Florida and wherever else he is will be safe for a little bit. Okay, so Karen Reed last night, let me just show you. So Aidan Kearney was really riling up the troops after these audio clips were released. I'm sure everybody's heard them. If you haven't, they're on my shorts. Go listen to them. But what it sounds like is two criminals talking to each other, screaming at each other, really. And if you lived on planet Earth for a little while, you may think, listening to those tapes, a reasonable person could conclude that they were up to some very suspicious behavior and actions. Just listening to those recordings, a sane person could conclude, just listening to those little clips, that these are two criminally inclined people screaming at each other, worried about getting in trouble with the law. They could conclude that. So right before Karen Reed threw a match on everything, we had a bus stop live by Aidan Turtleboy Kearney, and I thought this was interesting. Take a listen, where he's basically rallying up anyone who had asked questions about this and had wondered about the morality and just how Turtleboy acted, that he would be loyal to all the people. He's always loyal to the people who stick by his side. He remembers in times like this who's loyal to him. Take a listen.
Everybody have a good morning. Twitter blew up overnight. I tried not to pay attention to it. You might notice I really have been on Twitter much, but like I said on the other night on my show, I never forget. Okay. And I will, if you've been with me for this long, you know, there's always more to every story. That's it. And it will not be tomorrow. It will not be next week. But eventually, the whole story, is going to be told. And I will remember JFK and others. I will remember who jumped on the bandwagon and who was so quickly.
You know, when they say the story will be told, my experience of that is that when people say that, like, I can't tell you the full story now, but sometime I will tell you the full story. Like, it can't be told now when the person is accused of doing something really sus. Usually it means forget about it, and you never do hear the full story. It's like, just forget about it for now. And you never do hear that full story, do you? People have lived on planet Earth for a little while.
Quickly ready to accept Turtleboy bad. I will remember that. I will always, and I will remember who stood by me. I will remember that.
So it's not Turtleboy bad. It's like a great way to just not answer any of your critics. Just say, it's all because they don't like me. We see this in innocence fraud, too. Somehow everybody in Massachusetts wanted to frame Karen Reed. They didn't know her. They didn't even know who she was. But they all wanted to plant evidence, cover things up, and all pin it on Karen Reed. Not some 10-time reckless driver. Not someone with like some long history of reckless driving, or someone who's been in and out of that they were familiar with. They didn't find that taillight. They went to Karen Reed. Strangely, they knew that Karen Reed would say, I hit him, to all these first responders. But it's the same thing. Like, it's just all personal that everyone wants to say Turtleboy bad. Turtleboy bad. It's catchy, but it's just a kind of thought-stopping exercise. Don't look further. Don't think about it further. Don't ask questions. If you do, you're just saying Turtleboy bad. You're not being loyal, and you're not sticking by me. This is like some serious cult leader stuff.
So you can make your decision now about, do I want to jump on a bandwagon or wait for the facts to come out? Because Turtleboy has earned our trust over the years. Turtleboy always brings receipts. And there's certain things that...
So I covered 2 trials of cult leaders. Larry Ray, who was a cult leader on my alma mater, Sarah Lawrence's campus. Went to every day of that trial. And Keith Raniere, who I went to all of the hearings. And it was all the defendants, and then it was just, they all pled out, and it was just Keith Raniere, and I went to a good portion of his trial. And so this is like something right out of NXIVM or the Larry Ray story. Trust me. Don't ask questions. I can't talk about it. This is like what cult leaders do. You're either for, they make it us versus them. You're either for us or against us. And this was really successful until last night. And I'll get into that.
I'm not going to say, but I will. It will all come out. And I know everything. So remember that. It was like on Christmas Eve when I got arrested for that with Lindsay Gattani. Some people were like, wow, what the hell happened? He's got a Guman, Medfield. What's happening? She's pregnant, blah, blah, blah. And I'm in jail, and I couldn't tell my story. And I'm like, even some of my supporters I saw.
Right. He can't tell his story, but he can't even apologize to the people who he said were lying and show the receipts. Then they did show the receipts, and then he said he couldn't talk about it. So neither, for everyone who's saying it's AI, neither Aidan Kearney nor Karen Reed are saying it's AI. That would be the first thing, if it were AI, that they'd be saying this is a fake. The only people that are saying that are free Karen Readers, but not Karen Reed and not Aidan Turtleboy Kearney. They're not saying it. So just a little interesting piece of news. So here she is last night. I'll spare you. in JFK show saying, obviously I was recorded without my consent or even knowledge. He really, and we haven't seen the entire tape. Apparently it's a 30-minute tape that Aidan Kearney was passing around to people. There are content creators, Karen Reed said, who supposedly support me, who knew I was recorded, and they shared it with other people. These are people who supposedly supported me. Always the victim, Karen Reed. Always the victim. I asked for honesty and was lied to repeatedly. I mean, and it was like Karen Reed is the picture of honesty. How many times did Karen Reed get caught in lies? I did a turn. I didn't do a turn. I saw John go into the house. I didn't see John go into the house. Then she did see John go into the house. I did a 3-point turn. I didn't do a 3-point turn. I mean, these two are really cut from the same psychopathic cloth. So for all those people, they just remind me of Scientologists who want to do independent Scientology. I want to support Karen Reed, but I don't want to support Turtleboy. It's all connected in the same thing. Karen Reed was really calling the shots with what Turtleboy did, telling Turtleboy to go up to Jen McCabe and say this and ask Jen McCabe, you think Karen Reed can outsmart you? I mean, she was, I think we're going to see, we saw in the search warrants for, so the arrest warrants or the search warrants for Aidan Kearney, all the back and forth between them. And also you see it through the intermediary, Natalie Bernschneider-Weekamp, been over that a zillion times. And then here's Karen Reed inviting JFK to the next hearing. So now they've been anointed the next people, in the good with Karen Reed, the JFK show. Come to the next civil hearing. It shall be eventful. You can say hi to mom and dad. Yes, you're welcome to the civil proceedings. And then Nick Rocco says, look like the JFK show just earned a starting spot. No more 6th seat. So they've been anointed. The new people the people going forward, the chosen ones with Karen Reed. So let's look at a little reporting on this grand juror, shall we? Moving on to the grand juror.
Second trial of Karen Reed will spend 2 years on supervised release, including 2 months on house arrest. 34-year-old Jessica Leslie from Dracut pleaded guilty in August to disclosing information presented to the federal grand jury during the second trial. The information leaked included the names of various witnesses and the substance of witness testimony. In the sentencing memorandum filed Thursday, it says Leslie was fired from her state job with the Department of Children and Families.
So, yeah, that's what she was also crying about. Thank you for reminding me of losing her job. But then you can see Grant Smith Ellis put this up. Her mom stopped Grant and started screaming at them, beeped and started screaming at the reporters, and specifically Grant there. And this is his footage.
You beeped at me. You beeped at me. You beeped at me. You gave yourself away.
Right. You can't get it right. You never do, but she's interacting with him. I mean, this is how seriously she took her grand jury leaking. So she's crying in front of, just 20 minutes, 40 minutes before, she's weeping in front of the judge. So she's another actress. She's lost her job over this. And her lawyer says she did this all to free Karen Reed. So that's how.
That's unfair.
Otherwise, we would have talked to you. But you don't get it.
You're talking to me right now by yelling at me on a road. I'm a smart person. Thank you.
He says, thank you. So that's that. But I mean, just the maturity. And you're just taking your daughter, you've gotten sentenced, and you're yelling at press. We would have talked to you. They weren't talking to any press. But you never get it right. Nothing specific that he got wrong, just he never gets it right. Unreal, right? They're vulgar. Yeah, correct. We'll see. Just as she was leaving, Chris Albert was walking out for something else. I mean, the rumors are definitely a buzz. I don't know. I'm still skeptical. Call me crazy, but I'm skeptical that anything's going to happen with Karen Reed. I mean, they're really Karen Reed's are really above the law. I don't know what they found on her phones, but the grand jury meets on Thursday. So were they meeting? I mean, this is the question. Are they trying to, was the grand jury meeting on trying to indict Aidan Kearney and Karen Reed, or just Karen Reed of something else? I don't know. I doubt it though. I don't know. I'm so skeptical, but I'll be pleasantly surprised if it happens. I will be surprised. So that is that. Did I hit everything very quickly? Is that everything I have to talk about? I think so. Let me see. Hold on one second. Let me look at my... Yeah, there's that. I mean, just so interesting, and then here's JFK last night saying that just as Turtleboy said to him, here's JFK repeating exactly what Turtleboy told him. Hold on one sec.
Watch.
This is interesting.
Thank you. Going to jump. Tell people they do not know the full story with Aidan. They will. Talk soon. Come to Strager next time. I got you, Karen. Nothing but love, girl.
So Karen's saying they won't know the full stories. I mean, Karen's saying exactly what Aidan's saying here. She's threatening to throw out some full story.
Nothing but love.
And Aidan's threatening to throw out the full story. I think it's just a deflection technique.
Nothing but love. And I could show you the text right now, but I'm not gonna, because that's my business. That's right. Between me and Karen.
Right. They're now close to their queen, their accused killer queen, Karen. What a world we live in. So yeah, that's all the news to print, but very good news. I mean, can we have a little celebration with all her lawyers? I mean, does anybody remember her army of lawyers? Can we have just a reminder of what she walked into? Hold on. For those that forgot what Karen Reed brought into the civil hearing. I gotcha. I'm going to start talking like JFK. I gotcha. I gotcha. For those that didn't hear the civil hearing, I gotcha. Let's see. Hold on one second. Let me actually pull up Karen Reed's civil trial hearing. One hot minute. I just want you to see her army of lawyers. This is like absurd. I mean, she brought 7 lawyers to the.
Okay.
I mean, she brought 7 lawyers to this thing. So I think a little before here. Does anybody remember this? So there's mom and dad, and then so get to the part where they just all announce themselves.
Good afternoon, Your Honor. Good afternoon. All before the court is 2483 CV 692. This is the case of Paul O'Keefe and Alia versus C&C Hospitality, LLC, DBA, CF McCarthy. That Alia case is called for status and for Rule 12 motions. Counsel, please introduce yourself for the record, beginning with plaintiff's counsel. And if you could state the party you represent as well. Thank you.
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
Good afternoon.
Good afternoon. Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Charles Waters for defendant Karen Reed. Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. Erin Rosenberg also on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. William Keppel on behalf of Karen Reed.
Got it. Okay.
Good afternoon, Your Honor. Christopher George on behalf of the defendant Karen Reed.
Good afternoon, Your Honor. Marissa Palladini on behalf.
They're laughing. When it gets to them, they're laughing. Is anyone else interested in listening a little bit to? I mean, this is just kind of a hangout, but is anyone else interested in listening to Mark Diller's argument on this? I thought it was really good. Or would they be bored? I don't know. I'd like to hear it. I'd like to hear it again. But I mean, to just win, yeah. Okay, Darkside says yes. Darkside's with me. And everybody else can leave. It will be just me and Darkside. No one else is interested. I'd like to hear is, I mean, to go up against that many lawyers and do so well. So it's not really, it's really at this point. So her lawyer is saying she wants to sue a list as long as an arm. I'll just give you the, this is really for the Free Karen Reed people. And he's like, well, you haven't put anything in writing. We still haven't seen those filings. Has anyone else seen those filings of Karen Reed suing everyone else? They're like, this is a kind of novel approach. And here's Mark Diller. I think this is where that
2 cases and throw it as far wide ranging as they just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
All right, those issues are reserved. I'm certainly not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us
what is Karen Reed's IT guy doing here? Now he's like an essential part of her legal team. He's got to come to these hearings. Wasn't he supposed to be a neutral party? I was always found him very sus. Wasn't he supposed to be a neutral party? What is he doing at these things?
When I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. As we've briefed, Your Honor, the
Can we just skip past Siegelman? And I just want to get to Diller's part where he talks about the motion to dismiss.
Assuming all facts are true, indulging every inference in the plaintiff's favor, does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss, the lowest standard, the Brum case. Plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery.
If he's a lawyer, why doesn't he stand up and say he's representing Karen Reed? All the other lawyers who were, all the lawyers who working on this case stood up. You have to announce yourself for the record.
Should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright line test for such cases. Number three, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister...
That's such an important point, that these victims don't have a voice, and Karen Reed has done everything to make herself the victim and to ghost John O'Keefe from this story and actually make his family, public enemy number one. I mean, they have a million disparaging nicknames for Peggy O'Keefe, Paul O'Keefe, screaming at them in front of the court. I mean, whatever side of the fence, if you have any morality at all, you have to know that's disgusting. I mean, this family has been through it. Talk about trauma, and they want to talk about Karen Reed's trauma. Anyone see Karen Reed in their press conference in front of the court after this? She was so traumatized. She's laughing and joking, the happiest murder defendant. Now she's the happiest civil defendant. Civil murder defendant. Wrongful death defendant, whatever you want to call it.
Brother-in-law tragically passed 2 months apart from each other, leaving 2 young children orphaned. JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure.
That's something, I don't want to stop this too much, but that's something that I really wish Hank Brennan had honed in on, which is she didn't go to her own house. She went to John O'Keefe's house and she started plotting. The other thing that I thought that he should have brought up, I mean, I think he brought it up at one hearing, and he brought up all these things like you thought he was going to go gangbusters, and then you just never heard about it again. So just, I have some issues with Hank Brennan. Just my big issue that he didn't push for any prison time, because he is the voice of John O'Keefe in the courtroom. And I agree with Aidan Turtleboy Kearney. I don't think he realizes that I agree with him. That I agree that I think he was embarrassed and wanted to get out of that courtroom and just wanted to be liked. And your job as a lawyer is not to be liked. It's to do the right thing, even if it's going to get turned down. It's a symbolic act, even in front of Cannoni, who's always going to go Karen Reed's way. I really think he should have asked for her prison time, asked for the maximum when she got convicted of OUI. That's my feeling, and other issues. It's not that I don't think he did a good job on other things, but there are things that are key in this, like why didn't she call 911? Why did she have to call Jen McCabe and Kerry Roberts at all? Why did they need to be involved at all? She only got help for herself. She never got help for John O'Keefe. She knew right where he was. She's like, we really have to go back to the house? I don't have to take my boots off for this, because I know John O'Keefe's not coming back. No, he's dead. She's telling everyone that morning he's dead. To bother me about keeping my shoes on in the house. He's got a rule, no shoes on in the house, but it's not coming back to bother me about this. Then she's like, can we get through with this house search as quickly as possible? Because I really got to take you to the place where he is. She pretended not to know where he is. I think Kerry Roberts hasn't figured that out. I don't know about Jen McCabe, that she knew all along where he was. She's the only one that sees him out the door in a sea of snow. No one else sees anything. But Karen Reed can see him like a buffalo on a prairie. She's got like superhuman eyesight. She runs out. Let me out of the car, kicking the car door. Let me out, let me out, let me out. Runs on him, jumps on him with no fear, and rips up her shirt and his shirt to warm him up. Never does any real CPR on him, because she's got to do her hysterical act. Call daddy, get Karen Reed's section so she doesn't have to talk to the police. But without Kerry Roberts there, without Jen McCabe there, she would have no one else to mix into the story. And I think she's been doing this her whole life to get out of responsibility for her actions, mix in other people into the story that have human frailties like we all do, so she can accentuate them and point to them and away from herself. It is, I bet her life has been one big deflection campaign from her own behavior, her own psychopathic and abusive behavior.
In her life, she knows that Kaylee is a vulnerable child, having lost 2 parents tragically, and 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost two parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness at around 6 a.m. They rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtleboy. She leaks not for public information through him.
Can we just hear that again? That was such a good little summation of what she did. I would call it an innocence fraud campaign, but he wants to call it a propaganda campaign. Go ahead.
Conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation.
Fabricates a conspiracy. Conspiracy mindset is very key in a lot of these innocence fraud campaigns. You have to believe that something very improbable might have happened based on your imagination, not the evidence.
And she involves a blogger named Turtleboy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out first the wrongful death statute. It has two components for damages. It has two buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages. The lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings two separate causes of action. one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress as a concept has evolved in the Commonwealth is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct.
That was such an outrageous argument because Karen Reed hid her murder of John O'Keefe and plotted for hours. And she didn't do it in front of Kaylee's eyes. Kaylee couldn't have been traumatized. I mean, there was no need. If she couldn't reach John O'Keefe, call 911. Go back to the scene alone. You didn't want to. Why didn't you want to go back to the scene? She didn't want to go back to the scene with her smashed to smithereens taillight, which was seen when, does anybody remember that it was seen by the police when they did the wellness check on Kaylee? She didn't want to go there. If she didn't have Jen McCabe, if she didn't have Carrie Roberts, she went back to the scene, and everything, all her behavior that morning was to protect herself. It wasn't about John O'Keefe. It was all to protect herself and get out of responsibility. But they thought they would run with this because Kaylee didn't witness it. They thought, as Diller says, they thought that that was their best argument.
A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here in this court. And I see no reason why this court should overturn the good standing law that exists under the Cimino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. That the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on a number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident. Because as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing.
I'm sorry, Miss Mandy. Thank you so much. It's really nice to have you on board. You made my day. Glad you finally saw the light. Hi. Sorry to keep that up.
In those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliori case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone. Does not experience the injury and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim to suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own two eyes, I refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions. To suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness, it's hard to undo of it. It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim. So on that second, we also suggest that you should deny it because they experience the injuries closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Buell versus Wank, 1979 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Buell case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of a plaintiff to the defendant and her knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenge conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we pose to a jury. Kaylee was young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically, The defendant assumed this pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Miss Reed, knows that she knocked JJ down. It's in the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtleboy, to control that narrative. Why is Turtleboy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos that got published by Turtleboy for this vulnerable family to have to be exposed to that they weren't seeing before? To the extent that the defendant argues that this is not extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law. As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant always knew this. She has always known their vulnerability, and yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters, the O'Keefe family's period of grief has expired and they are now fair game. Discovery will track how much leaked information defendant should have known would result in distress to the O'Keefe family. To the extent that the defendant suggests that this case sits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases I cite. The Polay case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity. I want to talk about that briefly, because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtleboy, HBO Max, ID Discovery, etc. There are more. This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quint case that they cite where there's an open adulterer involved, and so they think That's not extreme and outrageous. And it's not extreme and outrageous like it has nothing to do with the employment case where they fired somebody who had a criminal case pending, and they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments. They should know that plaintiff's susceptibility and vulnerability are at issue in this case, and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you. Any response?
Yeah, that was my problem with the approach in the second trial, certainly, was that somehow Karen Reed was really hysterical. I think she was acting hysterical. I don't know someone who's really hysterical is going to jump on a body like that she knows is deceased. I think she was doing everything she could to create chaos, inflict a fear response in the people that she was with, and shut down critical thought. I mean, if you have someone scream your name over and over, I mean, everyone knows what that'll do to you. So I think this will be interesting if they keep sticking with Karen Reed. Doesn't do anything, she's such a plotter and a planner, and maintaining power and control is so key in these intentional acts. Of involving all these other people, mixing it all up, and it didn't matter to her. She was inflicting trauma on a minor who had been through a lot, who she had acted as a guardian for somewhat in her very limited capacity, but was part of her life for 2 years. I mean, the full story of what went on between Karen and Kaylee has really not come out. But we know that Kaylee and John had such a close relationship. They had such trust that even when John's not there, she's still obeying his rules and putting her phone in his room to charge. I mean, and he was texting her. We still don't know what that text was from the bar that night. That hasn't been put in the public domain. There's a lot of stuff that still needs to come out to tell the full story of what happened that night. I mean, it's not going to change who did it, but it will give us an idea of some of the more missing pieces. All right. That is a great job, Mark Diller. Very good result for us. Almost everything stays in for our side. Oh, hey, dystopian. No, it just Karen Reed, everything's a go in her civil case, pretty much, except one charge got thrown out. But it's a lot like another charge, I think. I don't know, at least on surface. I'll have to do some research, talk to some civil attorneys I know to figure out what exactly the difference is. And if anyone has the entire judge's decision, let me know. All right. Hit the like button on your way out. Good day. Diddy gets 4.5 years. Pretty good for New York with that small things he was convicted of. I think he should have been convicted for a lot more of those charges. Just my understanding of the facts of that case, but okay. He's a major celeb with mega bucks. We saw his supporters, you know, rubbing baby oil on each other in the front of the courthouse. Please hit the thumbs up on your way out. Support the channel. Venmo, buy me a coffee. Thank you, Tammy, for buying me a coffee. I appreciate it. There's someone else I have to thank. I think I'm going to hit it next time. I will do thank yous next time. Patreon, Venmo, buy me a coffee. All great ways to support the channel. I will see you tomorrow at my usual time, 6 p.m. Eastern. Have a great Friday, everybody. Happy weekend.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment. I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, gin, gin. Like John, you were my mark. My innocence fraud campaign is my biggest hit. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim.